Emma Munyana Kwa Babio about today in court. So a Joada said the Munyana Munim, the Supreme Court of Ghana, SI etna Sibio. Last week, Yasha Mobose and Sir Court Netas, Yabasia Benumre, at the Munch, Munim Pensen, Monetime, Abramunti, Yasna Tanasi Numre at the Sergio Mediano Air Bremo. And the 16th of February, Mobekaya Supreme Court had a ruling by on the application before it from the petitioner say na opese was sign Bonibe can reopen their case na omugina so editor nsa efre Electoral Commission chairperson Jane Adokwe Mensa na ono no eba be witness edema petitioner. The Supreme Court boss application no egui and I'm so Emma lawyers for the petitioner file application for review of that Supreme Court decision on 16th February. And then the court na etna so lawyers na one argument in every we court na the one ruling assign eba and home common the atna se anwumre ya de bramidi your sable so from obi jumedi etwegu e wa Adom 106.3 FM and Asempa 94.7 FM and afi Adom TV eso nondu ena yede jumedi no eba ewe se de bia ye no lawyer Justice Abdullahi trainee ewo University of Professional Studies, one law faculty. Papa since we began this election petition hearing on an Abuaye day today in court, Jumediano Abremo. Every day at Supreme Court Betinaseno, 9 p.m. Pepe. We are almost getting closer to the end of this petition. Mobekaya and the Supreme Court signed a date. Our one final judgment ebeba. Kokoye and Sem. Bebre. But even before that, no, a court nankasa so cite one respected member of the bar for contempt, former Deputy Attorney General of the Republic of Ghana, the Dominic Akorintinga Ayene, and the court na echene by Emma consequential orders be yebekoni nyinemu and enyumreni what it means to some of us are din komo efa Supreme Court in sensemi and when the ones who are wishing fie say ka contempt cry de asotwe be na possibly ewo de ema yebedi san komo nyina enne na afei ya start here a preview of ruling and as a judgment nyina expect nti be kan join us on all our social media platforms on Facebook Adom TV page on Facebook oko Asempanso page on Facebook and Adom FM page on Facebook obetuma hwe dwumadi live now the comments nso go ho ama yehia yen papa lawyer akwaba na pom to saying
yeah ni obi nyankopon ne mompa bonti akoba bibia
great me just say weekend niko ye
eje nya daje home kakra enye izi ababa na nkra ababa de eden
enye izi say akra stay by plan
ja ye de ya bro plan so the ne ya plan so but eja mate say ofri amana ne aba de ne kakra
oh sure
metin mfamam e be ofri ba no wo bebre be ofri ba nti eja ewi anu ahwe me kakra
but lawyer and as so what me ba kan ho aye de mo be call Supreme Court and shada ensemble na yakọ akọhwe let's give you a recap of some of the arguments our lawyers put across to the bench, starting from lawyer Chachuche Katawie na Justine Amenuvo representing the first respondent and Afe Akoto Ampa representing the second respondent in Sudan argument. To John Sana court near Kwan recess Edwin ruling Abba Ian Konkoshe.
By court, we are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on because my lords, in terms of the filing of the addresses.
Yes.
I was going to respectfully draw your Lordship's attention to the fact that there had been an earlier indication that you would provide a time
for you
oral highlights of my Lord. May I respectfully finish? That time has passed. I'm aware of that.
In the case of Mechanical Lloyd Assembly Plant versus Nati, 1987-88 Uganda Law Report 598, page 603 to 604, and the DJS stated, quote, "Let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in exceptional situations when a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. Secondly, in Chapel Hill versus Attorney General and another 2010 Supreme Court of Ghana report, page 827 at 850, the Tiban JSC further set out the parameters for reviews as follows, quote, "I do not consider that this case deserves any lengthy treatment. I think that it represents a classic case of a losing party seeking to re-argue its appeal under the garb of a review application. It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in a review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is." End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
And Justice of the Supreme Court, on one side, Chief Justice of the Republic of Ghana, Nidin Erianini Aboa, and the ruling of the court, just say, almost dismiss any application no, for lacking merit. Not just say, almost say the application, a free petition, and the whole buy, was not based on any known law. Said the OTA Chief Justice said the air to you lawyer enti OJ mre to me ehwe follow arguments no and a ruling the free court na ho bae na expected.
Oh, naturally na expected. It sounds nima bebre dodo na no me no waka no kokoro bi ha o kan bedwoma en sheda nyi no ahwe na ase wo say obi adwuma. Na at least the to any that so the I mean the to any e ma nyina yehu no the any or too obvious. Sebio imprensa so ni. And a review application about Supreme Court on. Me can say impre be ensan so kra so na the application occasioning the review no so asamba. Ni nyina no court no kan asem kro na. Ni nyina no parties ni nyina so kan asem kro na. Enti ne kremuni enne mo de na akwa last opportunity no. Na me expect say afanu no nyinaa bɛka asɛm foforɔ bi titru ɛyɛ petitioners no na nko bɛka asɛm foforɔ bi anka bɛtumi akanyan Supreme Court esan sɛ wabɛto nwom kora na nipa na ɔsɛ nwom no nyɛ de kɔbra na san bɛbɔ kɔbɔbɔ ho bra ɔsan ba ya nwom kora na chorus kora wansesa no yesa opportunity foforɔ san ba na sa bɛka wasɛm a sɛ da one should answer some be in fact same argument same bibia like literally it is ever not only this time Supreme Court na momumoye no omo sheda enya abotre to trying to distinguish between an appeal and a review because as a dodo na no ye sheda etutu anoma no ho ne de na ba say Supreme Court mo amhwe na anoma be na abo be ni na as a ye dada won bi na lawyers ye etaye enya de a ya de foforo we nya mano asem na make Supreme Court na e kan nsem nyina say lawyers dodo na sa asem no e ba na say woni court na Supreme Court na nya adwena in fact judges na omo kasa na mo sa kan asem kura e fo de make so say abri bia no decision bia no court bia be ma say bi obeya fa no mi nyina ade say ne tie bia de ono no walusu no obenya asemfo aka fa ho de ono no wanwe no ono so betima nya ansempa bie aka de abo asem ni si enti omo no de em say adware won enti omo nya de foforo mom
they are used to.
Thank you. Enti omo ti asese saa na yese ba na saa so ne beba no.
Because I think Chief Justice has spent their time on Mechanical Lloyd Assembly Plan versus NATE 1987-88 Supreme Court case as per Adade JSC. In the ruling, Chief Justice Ekan Bibia Ewakakra. The point about say Obi case and Koya, for example, Akawa say a person who has lost, and where Adade JSC is speaking in Mechanical Lloyd versus NATE, or say a person who has lost a case will almost instinctively feel that the judgment must be wrong.
Thank you.
And why not? If he had won, the decision would be right. So if he lost, how would the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed.
Thank you.
The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment.
Thank you. Enti minia so tie nsem nyina na eka fo ade na making so.
Yeah.
So in fact for the bare 3 occasions I atena se nyina no maka asisu dia se tambia na akwai se ase review no yen hye na nkan nsem na ho review no. At least utie the Supreme Court ne kana say me kwa na bia menye lawyer papa utie the Supreme Court ne kana tambia am say petitioners no omu ka omu na asem na according to the Supreme Court say omu ka ema ne kwa say appeal no omu ye na emu menye review nti no maba enti nne no say na make nne no omu hyeda enya abotre say omu ahwe say nsem ni sikona na de ye say omutimi kirem ye say ne impress aso ni da bia mo ba say review aso nsem ombeka nyina appeal ho asa na mo beka na sepani edwawia na nsu asa nti no omu nya abote no ma kirem am ye hu ne review na ne appeal eno mu nya abote kirem se waka se wo ba review a enkoba ne se ese emra no de enketenkete wo mu no kra na nka akra bia kra nka ese wo hu no Supreme Court ye hu isanse nipa se wo so ba for review dia enkoba se bibisa esiye nti ye hu nka kasa nka 1+1 is 2 Supreme Court mo kwa 1+1 am say 4 in fact 1+1 kra ma hu mpo mu twa mu ho se wo so ba review a na se 20 na oba se nti Supreme Court pa na nti 1+1 kra ma hu Nti we de yesre mo my lord monko check ho no yi na monsa ensese ne moye na anyi no monko yi
lawyer me home also wa ha me yakwa ba ye ba ye behwe argument a lawyer Chachuche Kata because ene no ono nso ko at length to make sure say two conditions was say ultimate meet and sana review jurisdiction we invoke ko at length because we shall say ruling was per incuriam or my reasons why you feel say per incuriam and some instances of feel say nam so review application when very very critical ye ba ye be fast and as a grounds no one after the other na fe yetimi akom ye na ne ho ne nkonkohwe we emresis ya. Today in court, Jubedi and Yade Bremi wa Adom TV, so Asempa 94.7 FM and Adom 106.3 FM. Medio say bon sufremi obi make say lawyer Justice Abdullahi Ewaha, lecturer UPSA Law Faculty, and Obwa Mayedi and Komoloya. Yen Sayamran 7 million ansana no petrosol ejumekona ebwayen. Almost clean fuel in full quantity is always a delightful experience. Yawo DBS Roofing, we truly are your roof expert. And your Coa mixture, the immune booster for your general well-being. And you will come and say, "Boy, me today in court, Abremo." And grounds of a review application, no, lawyer Chachuche Kata Ekan say, Bakone say Supreme Court ruling on February 16th, no, na lawyer for Mubro Phobia paying curium, and the reason and say. Even on the definition of the adverse witness, although no an argument or cited section 72 of the Evidence Act, no free say, Anka justice is your money ebesheho. But strange to him, no justice is not far from the Black's Law Dictionary mum. And also Black's Law Dictionary of persuasive effect there. They are binding, which is a statute ewa Ghana honeymoon. No court now fair no anye juma. But what your court ruling I say Shada anye bibi hu bia.
Nukreni the okana sa na te I was also expecting say e bia yenya ruling nkan yin ntini intimi sheda enya nti ase ne se de si ese enya no no sans enya se ye hwe TV so na se internet so nti den a unya absorption no as much as say enkrata ne de onim na wa wo kan before bia nti ase ese unya no benya na nya sa dia ni yegyina ete ne de anshada ampusume sene nanka ese epusume no okay sanse ne kremuni na menne petitioners no yes na ya adwene se yemra ya hyehyem na Ghana ha ne krem so America for ne Britain for so ahyehyem mumra ya America for ne Britain for ne sebiu abrofo moka brofo ye brofo ibi nyina no omuka English no ye ni omumra no esese
and the common law no
and the common law esse in fact to be a ana ya de krompo
okay
na ana so snake kitten bi na na dantamo so so snake kitten no because say o man bia da soronko nti o man bia de o mamamre ne o munni ye e ka omumra ho nya san de dodo na de nkamia ka say ya de kro na in fact one here between 60 to 70% of emra wo ya e kan brofo English brofo nyina na emra nyina epe sa be 30 to be 40% na aka no eno ye ebia ya peculiarities ne ye niema wo ya yemem no ene ye de ka ho se be ya be complement broni de no de abrɛ no British broni de de abrɛ no nti ene ya na ma nso ne kakra bi eba ye ne omomoka brofo ntem English ntem na essence no nti no abribia na na eta efa sebio emre wo saa amano ni nyina ebe kan de ho me de adwuma ma na yeyi essence eni mu nyina mra na yepe na essence mra na nya nyini nu ba bia ese duri nti no to de bia ne bebre ho a yesu afiri on ho na eno ne ma ne ko wie se ekoba se ese Supreme Court mo decision no na ese omuhu se ampa emra ni bi ho a emrofo na twro Britain fo ne America fo ma twro enwoma e fa sa ansem na ho na when the Supreme Court kofa o ma semi free ne kura mu ni sa ansem na mo kofa free mu no mra dictionary anisa ewi asem na nyina ye nyina obi a de adwuma na nya se bi a chekere enjechire na emum ye de adwuma bibia but wo de adwuma abra e fata se so de adwuma na enkoba se wonni sa wo de yem fato ho ana se wonni mra bia fa sa area no ho na ebia wo mane de chekere wo kakra na ye de ye wo emra e wo sa side ho no enti petition na nsem mo ka ne se ye wo mra ha no nko a de se wo so ko fa sa asem no de ayadwuma na ebia wo de be kire ni mama na se wo de be yem fato ho na nye se wo de be chekere wo ho ni ti a petition na nsem mo ka no enti na se Supreme Court ko fa de chekere wo ho ni enti no enne ma mo ebu atanchia na otwe etwa mu petition na nsem mo ka ko se no wo hwe mu aye na Supreme Court ni de ba he na o mu chekere nsem nim ni woye bia adverse witness dia woye hosta ni ade mu chekere ma ko wie se se sanipa no so obegina da kamumpo ansa na sanipa no watimi abone din se woye adverse na se woye hosta na enti nyese bia yekofa free Britain abuchi mama na se emfa free emra mu no ntino na ama na asesa ensesan to so biem kra no nipa opese okra umusem din begina da kam nipa kra so asem no onka ho bi ene nipa nkra betimi commission o betimi ma obia bebia dance sanse be nyina ya ka no hadada but utietie sanse ni nyina na enhyeda nyi asem na no ye enhyeda nyi anu ye at least not to me satisfaction so the medical can bia na mensanka text ni ntino e de bia ma adwene me say bia mensanka I probably would be more convinced but so before for na say bia no ye more convinced that maybe ye betimi agena adwene kire na yetimi hu se ne yese because enhyada enhyada mfaye so esan say ni mra ho ba bia de a it probably would be understanding say ye ni emra bia fa sa side ho ni ntino enti na bia ye kofa sa ho no bia
o zada na wo kasa say impo wo identify sa emra na e wo sanka Supreme Court yo madwen si so man for madwen si so enu nti wo betima gina so akọ review na
thank you
almost say ye de yadwen poko si so a anka kwan be na be fa so asesa
sa se anya nsunsan so kese bia
nsunsan so ben
enti no na still bani be ba
nti we reference
we sa no bia na bia no mo dwene akono no but bia sadaje na mamu se bia enso ne yantie ni ya o man hyeda an kwankopem ho no esan se utie sa nchechemu mu chechire ni nyina na as bibi sa na ya akwa wie so be friend say hostile so be friend say adverse in fact utie na say ni tia wa na say nipa no kura wo nyina adaka mu a untimi man say din mu bia esan say wo jana adaka mu an wo witness no wo jana adaka mu an nsem obeka na e be kire say
o hostile na
so we nipa foforo
ba be kai say justices ne ba ko busa chachu say okay into wo say your reference Black's Law Dictionary ya amfa section 72 in the far ya amfa no prove how it has occasioned a miscarriage of justice Emma Tatuka say if there is statute now one first statute na anya adwuma eno nko on its own no a miscarriage of justice and on my case law to support our position no
thank you and said the okay in fact until America said nanka me susu say gotta be more convincing argument from the Supreme Court because sabio eja say we chachuchi kata no be kan abrofo ni ntino eni e gbo na nsem agu ana say we petition na lawyer ni ntino so kana say enye kra yes ye ana say enye kra yes enye ne sa na ye ka nipa na raise issue so mu fi say bia enya mu hu ni enti enye but we have to admit says here because we are probably handicapped because you
need full
ruling no until we have to admit on that score so bia in second we probably can advance better arguments around these areas but as I sit here there so because me are convinced at this moment now me chatro
on that
particular angle of the argument
the be say after say court the omoje because you see the judgment no aba na say ruling no aba hon komo na EAD it adds up to the number of interlocutory applications a court no aboni nyina atogeda na yemamu hu say apart from the initial applications, a petition, and the call, you know, all the rest, and the court na boegu in unanimous fashion. So the what to me, see, a court na set date for final judgment, 4th March. Yawada day in now watch, and a court do a judgment on the 2020 election petition, no, the by John Dramani Mahama, Eden Seminary Court, say elections, and you may be ankoye arm and into coordination now on Mountain Stadium, and whole judgment nebeba on the 4th of March. But NABBSC, former Deputy Attorney General Dominic Akorintinga Ayene, court no etwe ne ba begina court yen komra ye ba ye be yi video na kire mo.
Adom TV. Adom TV.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
We have copies of the letter, and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. This is the order of the court. We accept the apology of learned counsel for the contemnor. We, however, order that the contemnor purges his contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, we will come and completely vacate the order.
Yes, I'm a munyana kwababio eba Adom TV. So today in court, Jumedie and ye share a day abremo enche Jumedie and beba awie said the medical akano after second nedi won ruling eba you know lawyer Chachu Kata make case anke beya court na ema ne kwan kakra na omonhwem file won written submissions no court no so ebogui because they sought the leave of the courts for an extension na nko mwetimi a file one written submission. No so court no ebo etugui. The court na say by ochena enwumre e was so more written submissions no etimi eye ready. And which you know and court neton safre former Deputy Attorney General Dominic Akorintinga Ayene yenkoni yenkonkohwe de course.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
We have copies of the letter, and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. This is the order of the court. We accept the apology of learned counsel for the contemnor. We, however, order that the contemnor purges his contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
Okay, and Chief Justice and Yabua and the orders of the court etuja. Lawyer say court ne shall say ye be to purge the contempt. Now, oh yeah, I was a court decide na say. Or say they would come and vacate the order. I know what you're saying.
It can say a bo Supreme Court abaso say sans and some honorable kikan no omutimi hu ni mobo kwan krom fa so e di asem no I think say asomani
okay
asomani pa isan say adana doctor ini kikan asem na no mje jama menne fe lawyer say di kan mse ye kan nim kakra san sem na ntwa ye kra na abra mse jama nsem no tre no amanfo sha ase ye dede se oda bi ne e kono say contempt na papa no say ye frɛ no na okoda nsem kakra okoda nsem ba bia de man ne kekan nsem hunu sa na bia obadwene no aka free na ko waka nsempa na me sense studia sam mran sans sam ne sha ase na me studia so papa no wabo aga na yie o kwan bebre so sebio ajaje fo no moto ni nyina dodo na ono mo ye adwuma abra na oye attorney general ne deputy ono mo ye adwuma bebre enti omuni ni mo ho kama omo ye namfo na minim sebia no na ama ne wan mu ade ma o keka nsem o keka ye no ana bia no kan ho sometimes ana kan say familiarity ana bi di contempt kakra minim ne e ma ne ye keka nsem sa up to now metias enyi but na me de na me mpa ba ne say nkem ko wie contempt
okay
nyame nanim ne ye e ko wie contempt but say the Supreme Court handle ye no I think say eno cry better than na me de kwa na me ka say ni kwa so mo friend contempt no it sounds say omo fa no omo che no with contempt no punishment o ha ye say de ma no ama MC nyina ye disua ehun say o Supreme Court omo nkata o mani no mo nsisi o maso wo ya omo no bedi enu di so a enu bedi ne nyonyon no so na se omo bu o mani gu ni ma bi so na ncha say bi o mada enti ama at least ebuo bi ni hu kakra bi abam nti obia ye ne niam obehwe ni yi o mama na nkoda afia ase de ne mo mma ne kwanya ono ankasa okọ no kra no na odi kan de na chopa kra akọ the day before ne lawyer no men kam obi anim tia ne lawyer no dwene hu yi se de ekọ no omupom mpo anhwe afia ase de bokọ akoda nti ne lawyer no o dwene hu ehun the best approach sabio 2012 me kan bibi se woni mumra eya Supreme Court na akọchire mumra ana contempt na akwaya de bi se court no mum a cite for contempt no na akwaya de bi se we are guilty crimes na obedru ho
in the almost over come and show cause why we should not but chema de kon was here do konsa we na
min shraw so tie se de mran sitie na the Supreme Court to throw pe on the charge of contempt it means what in so mu dada ne mo afemum na wo be kire kwan kra se you free nsawom enti ana ne Canada enti ye nko kamera ampa meka me se afutu etu dwa no me nkasem eno ntiremum nemum ancha ena mo amonkofo ibaako Mr. Jamara Black Rasta say
Black Rasta
ena parliament citing for contempt said the Dr. Any dey ya sa na nso koye before bedru ho no na chopa no kra dru ho
kodada
odu o mbisa no so mse no anom nema bi enti mse fa na ni so kakra na ma ne kanse mu no akoda ne asresem obi a okoda afiase no okobi na akoda ne asresem na me so okay ne nya hwe ene no so kopacho na twen sem na kan ne san na free na ko nya biem ni tiawa semetu atwa esan se emra ya adwuma de ne so emra no eni nyina so wen nyina ka mra no ho se nya frɛ wo kobu obi anim tia na se pani ne frɛ wo se bra na be yi ano abra wo no unia no yie bia yɛmfa sɛbio ahomasoɔ na ɛkɔ
ɛna ɛkɔ
yɛsɛ kasade ɛma abaatɔ
ebi nso sɛ yɛyɛ saa na sɛ yɛpɛ sɛ yɛma court ne yɛ a mercy chamber court ne nso nyɛ mercy chamber ayɛ a chamber of law
ne korɛ
ɛdɛ na wokɔ a wonkɔ kamera na wokɔ akɔpa kyɛw
san sɛ yɛ baabi yɛ kamera yɛ baabi yɛ kamera ɛne yɛ da yɛ kamera da yɛ kamera ne duru ha wa kamera da sɛbio yɛ paakyɛw a eduru ha paakyɛw saa da no ɛyɛ wofa ahodie ho asɛm ne yɛka sɛ mmara no yɛ papo sɛ nyɛ papo sɛbio yɛ ɛnni wachi ɛmɛda nsɛm na sɛ na awtwe mi no so bosome ɔmɛda hɔ bi side check ɔma hɔ bi sɛ nkɔ baba hɔ bi kura ne sɛ nka megyere sɛ nka ewiase fa nyinaa nka Ghana sɛ mɛma fa na bɛkɔ akɔda efiase ɛsa sɛ sɛ nka hɔ bɛboa nanso nyɛ saa na ɛkɔ no enti wo dwene ho ano adwene ho mienu sɛ enti me kɔ yi me nkɔ kamera na sɛ memfa me fie nyansa nkɔ paakyɛw sɛ yɛbɛhwɛ a ɔmo de fie nyansa kɔkɔ paakyɛw nyinaa ɛyɛ adwuma ma wɔn ɔmo de mmara kɔ nyinaa no ɔmo ne nsa ɔmo ne ho maximum prisons deɛ ɛmo sɛ ɔmo fa anamfoɔ enti ɛbɛboa sɛ yɛduru baabi a na ade wonim deɛ ɛne wotumi ato nkyɛn
kakra okay
ɛsan sɛ tumi na ebi kyɛn bi
la emre ne ntisi na the court ne hyɛ sɛ ɔnyɛ no wapa kyɛw no Thursday court ne ba
vacation no asekyerɛ ne sɛ wɔyɛ wokɔpɛɛge wo ho wie a kɔsa wo yam kɔsa wo ho wokɔsa wo ho wie a na woba na sɛ court no sampa wo yam nsuru nyinaa firi wo yam sɛ biribiara ni mu wada ne mframa afɛ na ebi a court no bɛtwi w'anim kakra
okay
na nka asotwe anka bi a ɔhɔ foforo bi anka sɛ mo de ma na sɛ mo de ama no no mabɔ ne nyinaa gu
okay
so ma ngu a titiro no akɔ member of parliament no ɛwɔ nsunsuan so bebree ɛno nti na wɔ no de mo de ahyɛ so saa no so ma ngu a ɛyɛ asɛm because yɛ convict wa ɛyɛ asɛm yɛ sentence wa nsɛm bebree enti ɔno de ka de ɛwɔ
sɛ ɔmo ngu na ɔmo ma conviction ne sentence to be a fine kra no kra ya asem
message say sentence o kra se kopra wa kra fie dem kra ya asem because nina it means that you have been convicted and none doesn't even look at even sentence it looks at conviction and because sentence there e bet member say obenya the most minimum sentence enti hokra de na entan hwe honom e conviction no
say ye buafo
see you buafo a one hwe odi member of parliament
enye say and a criminal say contempt
quasi criminal so into one hwe na hokra san sakobo enu ntina so hwe ya enne wono a ne honhum na yira ni se ne tumi ne anije onu mu nyina ayira in fact so behwe a for the first time afanu ni mi nyina ya press conference ni bom ko ba bia na adu no na emu ye den edu ba bi na say den ka say den enso bo wa ni ya jitu
chale
enti edu ba bi anya better sa eni kwan say enima bi kwa wo twan ma ne to wansa
okay
so behwe ada na me kan say sebio yemfa politics ene sebio emotions yenke kanse hunu bi sa ke kan yo pe bia Supreme Court entimi nka da kokra ba bia da so entimi disagree with omo position ya betna hede bia de omo ya efisi ene omo nya adwene ne ka nemom in discussing the merits of sansem no limit or comment to attempt the DNA personalization ne emfa sa ne mane mam ehu hia titu lawyer pani ete sa ne kra de won kra de onim kra sem mpo infa se bibi kra no kra na kire made se ye bibi mpo kra
that's true
and when you onim se ya ete ha nyina
okay enti lawyer yebeda say emre no aso unfortunately was say hwe ne ye disi ye na petrol solar ye na DBS roofing ase na ye na coa mixture enso ase nyame ya adomo a on the 4th of March se court did your final judgment ba ye be say about betena say today in court abremidi your say bonsu from obi have a good evening nyame ya adomo yen say on the 4th